All right, so thanks very much, everybody, for joining us this morning. We're going to be together probably for the next hour and a half or so. I don't think we're going to be very long. And I did email out with the invitations a copy of the slides that we're going to be referring to this morning, as well as two other documents, excerpts from the Bargaining Council's exemptions policy and the actual exemption application form itself. Hopefully you did get copies of those. Otherwise, we'll be sharing them during the course of the morning. Chloe, can I just ask that you give me an indication that you can hear me fine, see me fine? Not important that you see me, I guess, but hear me fine. And also, is the presentation showing?
Hi, Gordon. Yes, the presentation is showing. I can see you and I can hear you.
Okay, excellent. All right, just before we begin, some housekeeping issues. I haven't disabled any of the functionality on the platform, so you can toggle your own microphones and cameras on and off. There were 27 people booked. As I can see now, 14 people have joined us, so we are missing a number of people. But be that as it may, I think it's a small enough group to be able to have discussions while we're going through the material. So please don't feel that you have to keep your questions for the end necessarily. Rather just raise your question as we're going through the material. Please just may I ask you one thing, that if you are wanting to ask a question or you're wanting to stop me and cover something or make a point or whatnot, please don't use the raise hand or thumbs up emoticons, because when I'm in presenter mode, I can't see any of that. I can only see the slides. So just rather untoggle your microphone, ask the question, we'll have the discussion, we'll deal with it, and we'll move on. You can, however, if you prefer, use the show conversation icon if you'd rather type your question out, and Chloe will be assisting with queries there, or post the question and we'll revisit those questions and deal with them towards the end. Okay, so then I'm just going to move to presenter mode. Just one or two other people joining us. I'm just going to move to presenter mode and then we can kick off. All right. So we're here obviously to deal with the exemption process. We are in a situation where we've secured an agreement, albeit with one trade union only at this point in time. We've secured an agreement, and that agreement is obviously binding on our members as an association. The members, therefore, who cannot meet one or more of the requirements of the agreement will have recourse to apply for an exemption from that particular aspect. So by way of an introduction, I mean, a few opening comments from my side. I know I'm preaching to the choir here by saying that 2020 and 2021 have been exceptionally difficult for industry employers. We've had lockdown, we've had the COVID-19 pandemic, which is ongoing, obviously. I just saw a slide pop up on my computer a few moments ago talking about the fourth wave that's on its way, and all of the lockdowns associated with the COVID-19 pandemic, as well as the strike action that we have just come out of, have placed enormous pressure on companies, and the economic indicators are not that great. So the ones that I've been looking at anyway are all indicating that it's going to be quite a tough time for at least the short to medium term in the future, depending on certain things that may or may not happen, etc. And the annual shutdown period is particularly difficult. Wage negotiations were somewhat different this year in that they continued for a lot longer than they might have done ordinarily. Very often we will see wage negotiations being concluded much sooner, closer to the middle of the year. For example, this year, unfortunately, they were drawn out, and the strike action took place very, very late, and that, of course, didn't help matters, made things a hell of a lot worse. And now we are facing the annual shutdown period, which is in any event, in any normal year, if I can put it like that, quite a difficult time because it's the least amount of hours worked and the highest wage bill, given that employees are taking leave, they're paid leave enhancement pay and so on. But relief from these aspects can be sought through the MEIBC exemptions policy. Relief is available in terms of the terms and conditions of employment agreement that we have with Solidarity, and we'll be going through that. So just to let everybody know what we're going to be having a look at during the course of the morning, we'll start by looking at the exemption process. What does the law require? The law in terms of the Labour Relations Act, in terms of our collective agreement, in terms of the various policies, etc. What exactly is required? What does the exemption policy itself say? And what is its efficacy? I mean, what are the success rates? What are the chances that an exemption will be successful if submitted? And those types of questions as well be answered. Composition of the committee. The exemption application is processed by a committee. Who sits on that committee? What are their roles, etc.? How do they make the decisions? We'll be covering all of that. The independent auditor. Independent auditor is also a role player in this process. Looks at obviously the accounting information and the financial information of the company, and we'll look at specifically what he does in terms of making his recommendations and so on. We'll go through the exemptions process from beginning to end. What I'll do is I'll go through the actual application form, make certain comments, and then we'll share tips and have discussions around certain aspects of that exemption application form while we're going through it. And that includes tips on how to complete forms and consult with the employees. I know there's a specific sheets, this word has just gone right out of my head, forms that need to be filled in, etc. It's not always necessary to stick to those forms. Sometimes the employees don't want to sign things. Sometimes the union don't want to sign things. We'll look at ways around that. What happens then if the application is declined? Is there any sort of appeal process? The answer is yes. The Independent Exemptions Appeal Board plays a role in that regard, and we'll look at what guides them, who sits on that committee, and how to deal with that if the answer to or if your original application is declined at the first stage. We will have a questions and comments session at the end, but please, as I said, don't keep your questions and comments to the end. If you'd rather ask them as we're going through the material, if we're on a particular slide or on a particular page, then please ask those questions as we're going through. No need to keep them. No need to keep it so formal, and keep your questions to the end, as I said. Okay, so let's kick off by just having a brief look at what the law requires. I mean, this is just background information. Don't really need to know this in terms of actually making an application itself, but the Labour Relations Act does, under Section 32, deal with the extension of collective agreements. I'm just going to run through this very quickly because, as I'm sure that most people on this webinar are aware, the possibility of any collective agreement being extended is quite remote at this stage. There's different collective agreements at play within the scope of registration of the MEIBC. There's an agreement between CIFSA and the trade unions. There's an agreement between ourselves and Solidarity. There's a plastics agreement between the plastics and, well, all of the employer organizations except for one, and all of the trade unions except for NUMSA, and all of these things are playing a role in terms of the extension of any one agreement. Besides any of that, and probably much more importantly, there is no two parties to any particular agreement that represent the majority of employees within the bargaining council, and that's what is critical in terms of the extension of agreement. That's why none of the agreements that are currently in place between the various parties are likely to be extended. So as much as the Labour Relations Act does deal with this and does talk about an agreement only being extended if it makes provision for exemptions for non-parties, the important takeaway part of this is that there's an underlying principle within the Labour Relations Act that says that if an exemption process is catered for in a bargaining council agreement or in the bargaining council set up constitutional policies, then those exemption applications need to be processed within 30 days of them being lodged with the MEIBC. And that's just to give you an indication that the application process itself is fairly quick. It's not as drawn out as a lot of people might expect. And that's because of this particular underlying provision in the Labour Relations Act, which requires an exemption application to be dealt with within 30 days. It's not always possible, and there's no guidance from the Labour Relations Act in terms of what might happen if an exemption application is not dealt with within 30 days. The answer really is that it'll be dealt with as soon as possible, but the Bargaining Council and the parties do endeavour to process these applications as quickly as possible, certainly within that 30-day window. For that reason, most of the regions, certainly the Gauteng Regional Office, which is the region for Gauteng that deals with the exemption applications, holds Bargaining Council Exemption Committee meetings every 2 weeks. So that's kind of the turnaround time, and this is why we have that in place in the Bargaining Council. So the Labour Relations Act also requires the constitution of every bargaining council to provide for the procedure for a company to apply for an exemption from collective agreements. And our agreement is no different. Our terms and conditions of employment agreement, that's what we call the agreement that we have with Solidarity, the TCOE agreement. And that makes provisions for exemptions from parties under Chapter 15. And we've included it was sent out with the invitation to this morning's webinar. We've included excerpts from the exemption provisions in our agreement. I did take some of the stuff out because there's a long section that deals with labour broker package rate exemptions, which isn't applicable to anybody on today's webinar, and it just takes up space and has many forms that probably just confuse people. So I've just taken all of that out and made notes which indicate that, but the other provisions that you do have access to are there for you. If anybody does want a full copy of the entire exemption provision, just email me and I'll send it through to you. And the provisions of our agreement, they're the same as those that appear under the main agreements, but they make provision for different types of exemptions. Effectively, the principle is that a company can apply for any person, or a company can apply for an exemption from any aspect of any collective agreement. Okay, the most common types of exemptions that are dealt with under our arrangements are the struggling business exemption, which makes provision for different types of things, like, for example, exemptions from wage increases, exemptions from minimum rates of pay, exemptions from paying leave enhancement pay at the end of the year if you're observing a shutdown, for example. And that's what I would imagine most people on today's call are here to hear about. But there are others. There's a small business exemption. Now, a small business exemption is available for a very new company, so a company that is less than 3 years old and employs 10 or less scheduled employees, 10 or fewer scheduled employees. With the small business exemption, provided the application form is completed correctly and the information is submitted, etc. A small business exemption effectively exempts a business from all of the provisions of the collective agreement for the first 3 years. But by far the most common exemption application that we deal with at the Bargaining Council level is a struggling business exemption, where a company is struggling financially, let's assume for whatever reason, and needs relief from a particular aspect of the agreement, be it wage increases, wage rates, minimum wage rates, leave enhancement pay, etc. There is another very common exemption application which is applied for, and that's for overtime. So if a company wishes to work more than the 10 hours overtime permissible in terms of the agreement, there's an overtime exemption which can be completed and submitted. And with overtime exemptions, just for information purpose, although I doubt anybody's on today's webinar to get guidance specifically in terms of overtime exemptions, but just for your information, because of the nature of the urgency of a lot of overtime and overtime exemptions, the Bargaining Council has been given administrative authority to grant those exemptions. So in other words, you don't have to wait for meetings to get an answer in terms of an overtime exemption. As long as certain criteria are there and the application form is sound and properly completed and submitted, the overtime will be granted by the Bargaining Council itself upon application or upon submission, effectively. So if we look at the Bargaining Council, if we consider the Bargaining Council exemptions policy and its efficacy, as I said, the MEIBC exemptions policy or excerpts from it is included in the course material, was sent out with this morning's invitation, and you can read through that. Historically, the exemptions policy has been quite successful for companies. The vast majority of exemptions, certainly in my experience, and I've been serving on these exemptions committees since 2003, the vast majority of exemptions that have been sought have been granted. It's not uncommon in any given year for the success rates to be over 80%, so 85% success rate for employers. And I think the reason for that is fairly logical and simple, in that companies don't apply for exemption unless they need to. And if they need to, there will be the evidence that is necessary to support a successful application. It's just a case of going through the motions and making the application. The process, however, is quite cumbersome. It's fairly lengthy. There's a lot involved in it. And I think, unfortunately, that leads to a lot of companies who might be successful with an exemption application simply not bothering. I've been told by a lot of companies, well, we didn't bother for an exemption because it was so complicated, at least on the surface, and there was so much information required we didn't even bother, which is very, very unfortunate. And because of that, we and Solidarity have committed to one another to redraft the exemptions policy, making it far simpler, far more efficient for companies to apply. We're wanting to get, as SAIFA, to a situation where an application is as simple as possible. A few calculations are done, and if the answers that are arrived at through the calculations, are X, then the exemption is simply given or issued, and it's a very simple and easy and straightforward process. Unfortunately, however, we do need to negotiate that, and we've committed to try and get that done within the next 6 months, which we will do our utmost to do. Unfortunately, however, until we have something that replaces the current exemptions policy, we're stuck with what we have. So that's why we are making use of the policy. That's why we're running this webinar. That's why we're assisting companies who are in need of exemption applications at this point in time, just before the shutdown, etc. And we're helping companies through that. I know many people have already started with their processes. There's people on this call who have already submitted their applications and so on. So we are getting into the thick of it. I want to, at this stage, as I was preparing for this session, I thought it might be best at this stage just to step away from the slides. I know there's more to come, and just bring your attention to the application form itself, which I'll bring up on the screen shortly. Okay, hopefully it's showing. Let me try and make it a bit bigger. I just thought that it might be very useful for companies just to go through the actual exemption questionnaire itself. If you've been dealing with the questionnaire and it doesn't look exactly like this, don't worry too much about that. But the format should be more or less the same. Some of you have already filled this out. I've seen some of your applications, and I just want to go through a couple of points in this exemption application questionnaire itself. All right, so when you are contemplating applying for an exemption, or when you're in need of some or other exemption application, you'll need to do a couple of things. Firstly, you'll need to fill out this exemption application or exemption questionnaire, and you will need to consult with your employees and or their trade union. Okay, so I just want to make sure that everybody, although the questionnaire is fairly simple and straightforward and self-explanatory, I just do want to run through it with you just to point out a couple of things. So this questionnaire needs to be filled in. It's fairly straightforward. Date of application is the date that you fill the application in. Council registration number that you can get. If you have any problems with getting your council registration numbers, let me know. I can contact the council. I know who to get them from if you are struggling with that. Otherwise, it should be filed away somewhere. All of the contact details of the company. At one point, this is quite a common area of misunderstanding. We had a lot of companies who fill in here that as the name of their employer organization, they put the name of the company. That's not what this means. This is asking for the name of your employer organization or the employer organization to which the company or of which the company is a member. So in your case, this would be SAIFA. Okay, that's important because it guides the committees and the bargaining council and everybody else involved in terms of what exemption is being sought and what the requirements are. When we were in the past all bound as an industry by one agreement, it made no difference whatsoever because it didn't really matter who your employer organization was. The rules were standard and gazetted and extended across the board for everybody. This now makes quite a big difference because since 2017, technically since 2011, but let's focus as an association on what binds us. Since 2017, the only employer organization with an agreement that its members needed an exemption from was CIFSA. Nobody else needed an agreement because there was no agreement to bind anybody else. Now there's multiple agreements, as I explained earlier. So this point 1.8 needs to be filled out by anybody on this particular webinar to say SAIF, or South African Engineers and Founders Association. The activities of the term, just a brief description of what it is that you do, whether you're a foundry, manufacturer, etc., etc. The rest is fairly self-explanatory. Total number of employees, total number of scheduled employees. Just to point out, for those of you who aren't familiar with the term scheduled employees, a scheduled employee is anybody employed on the shop floor from a rate H to a rate A. So it's all your typically the employees who are typically paid wages as opposed to salaries, etc. But the employees employed on the production processes on the shop floor. Those are the scheduled employees, the employees covered by their collective agreement. The total number of employees includes everybody else. So your office staff, your admin staff, your ground staff, security, etc. If security isn't outsourced and so on. Is there any trade union involved? If there is, which trade unions? And then are the terms and conditions of employment agreement rates for the 2021-2022 period being paid, yes or no? Hopefully they will be being paid, although as everybody on this call is probably aware, we do have 3 years, the period of the agreement itself, to catch up with the what we call base or standard rates of pay, which are stipulated in the minimum tables of our agreement. If you are in that situation where you are still catching up, then you simply state that, no, we're not quite there yet. We're paying 75%, etc., whatever the case may be. Then the exemption details itself. 3.1, what exemption is being applied for? So there, the two most common, I think, as we've already mentioned, will be the exemption from a wage increase, exemption from paying leave enhancement pay. Those are probably the two most common, maybe closely followed by an exemption, if necessary, from the actual minimum rates of pay. That's probably the third most common. So that needs to be specified here. If you are wanting to be exempted from more than one, then simply put let's say, for example, wage increases and leave enhancement pay, whatever the case may be. But it needs to be quite specific. It guides the readers of this document just quickly in terms of what application is being applied for. Then, while the directors, members, or owners of the firm, shareholders in any other business, this is kind of obviously something that was inserted once upon a time through negotiation with the trade unions, most of them being sort of socialistically minded. They're saying, well, perhaps if you've got another business, you can cross-subsidize and all of this sort of nonsense. Unless it's very, very obvious, I would simply say no. And then the rest is fairly self-explanatory, but very, very important. For example, here, 3.4 of the trade unions being consulted. Don't be in a situation because you realize that consulting with the trade union will be difficult, uncomfortable, and even unpleasant, perhaps. Don't be don't get yourself into a situation where you don't then consult with the trade union, because what happens is when this application then comes across the table at the committee meeting, and I'll go into the composition of the committee meeting, the composition of the committee members later, but some of them are trade union members and trade union officials. The minute they see that the trade union hasn't been consulted, they're simply going to say, well, this application needs to be rejected, needs to be sent back, and the company needs to consult with the trade unions involved. Obviously, if there's no trade union, then not applicable. But if there is a trade union, you have to at least consult with them, even if they don't agree. It's very, very important to understand that as part of the application process, consultation is required, not agreement, and not negotiation, which presupposes an agreement being reached. So it's hard to put a percentage on it, but I would say easily 75% or so of the applications that are dealt with, certainly at the Gauteng regional office level, the trade union has been consulted, but the trade union doesn't support the application. Date of the consultations, and did they support the application? As I said, yes. Yes is sometimes the case, but no is more often the situation there. If you are in consultations with the trade unions and the guys don't want to support the application, feel free to put some pressure on them. I mean, obviously don't bully anybody or anything like that, but feel free to put some pressure on them in terms of explaining why they don't support the application. I mean, if you're consulting in good faith with the trade union and you're saying, guys, unfortunately, through whatever circumstances, we're not able to, let's say, for example, pay leave enhancement pay, and you've demonstrated that, you've shared the information, you've really tried to get them to understand the position, and they say, well, no, we don't support the application. It's perfect. You're perfectly within your rights to say, please, guys, we need to know why it is that you don't support this application. We need to note it on the form. We want to know exactly what it is that you are not in agreement with. We understand that it's, nobody wants to have to consult over an exemption application. Not a pleasant thing to have to do, but we do want to know why it is that you don't support this application. See what they say. They refuse to give you any reasons, then note that on the form. Okay. Because it is useful sometimes just to understand where the trade unions are coming from in terms of whether or not they support the application and why. Have the employees been consulted? Well, if you do have a trade union presence and you've consulted with the trade union, the employees will have automatically been a part of that, so that'll be yes. Otherwise, if you don't have a trade union presence, then consultation with your employees is the way to go. And same question there again, did the employees support the application? Yes, no, and if not, why? I will probably repeat a number of things during the course of the presentation, so forgive me for that, but it doesn't harm to reiterate certain things. I just want to say at this stage that very often, particularly now and particularly NUMSA, if you are going to be consulting with them, there might be a reluctance to support the application, and that's not uncommon. That's fairly common, as I said, but there may even be a reluctance to engage at all. There may be a reluctance to consult, and it's very, very difficult. There's no sort of general theme from what I can see. It just depends on the trade union official concerned. At some companies, where our members are applying for exemption, they invite the trade unions to come and consult, and the trade unions say, there's nothing to consult to consult over. You're not part of the agreement that we have with CIFSA, so you're not bound by any agreements. I've had that approach taken by the trade unions. In other cases, they simply say, well, we don't recognize your agreement, we're not consulting with you. And in other cases, they're quite happy to consult and they're quite happy to come out, etc. So whatever their response is, whatever their answers are, even if they don't respond at all, form a paper trail of what it is that you're doing and any attempts made to consult as well. Because if you submit this application and you say, no, the trade unions haven't been consulted, but you don't explain that they haven't been consulted because they refuse to attend consultations, upon their invitation, then, that's going to be lost to the committee, and the committee is going to see this and send it back and say, well, you haven't consulted, then we can't process this application. Just always support everything with the necessary paper trail or the email correspondence or whatever it happens to be, and attach that. Another trick here is when you invite your trade unions or your employees to consult. Sorry, just before I get onto that point, another issue is that if you invite the trade union to come and consult and they say no, there's nothing then stopping you from going to your employees and saying, look, guys, we invited your trade union, they didn't want to come along. Well, this is the situation, this is what we were wanting to talk to them about, and you can consult them with your employees. But if you do have a meeting with your employees or the trade union or both, whatever the case may be, it's always a good idea to get into the habit of circulating an attendance register before you start the meeting, okay? Because typically employees and trade unions don't necessarily have a problem with signing an attendance register, particularly if it's circulated at the start of a meeting or before the meeting has started. And then once everybody's completed it, then you can start the meeting, and that then can serve as your proof that a consultation did in fact occur and that person was there, or your employees did attend, or the union official did attend, or whatever the case is. But once you start the meeting and it becomes apparent that it's going to be a fairly conflictual meeting about exemptions and things like that, and you circulate an attendance register, or if you circulate the minutes and you ask somebody to sign, or whatever the case may be, then there might be that reluctance because they don't like what was discussed in the actual meeting as well. Right. So any proof or evidence that a consultation has taken place must be included and gives us something to work with when motivating the exemption application on your behalf. Okay. So obviously that consultation meeting should be minuted. Okay. Doesn't need to be very, very it doesn't have to be a sort of word for word minutes, but just a basic record of what was discussed. Were the signatures of the officials who attended the meeting, are they, do they appear, are they on the minutes, etc., etc. If the answer there is no, don't worry about that. But if it is no, provide a reason. No, the trade union official refused to sign or got up and left before the meeting could be concluded, or whatever the case may be. You'll encounter all sorts, unfortunately, with this type of consultation. Signature of the employees attended the meeting, same thing. Then the question is asked, has the company in the last year implemented short-time layoffs or retrenched any employees? That's just for the readers of this application to get an indication as to any sort of underlying problem with the company. Is it something that, are we dealing with a company that's in quite a lot of trouble, has had to undergo retrenchments, etc.? If that is the case, just take some time to put that in and specify the dates. Maybe you've worked short time a couple of times during the course of the year, or whatever the case is. Then under 311, it asks, are the firm's contributions paid up to date? What that means specifically is your contributions in terms of the industry pension provident fund contributions for your employees. Okay, all of those contributions should be up to date. It's not something that you want to fall behind on. If you do, MIBFA, being the benefit funds administrators, will be on your back. They'll want you to catch up, and you can always make arrangements in that regard. But if under 311 you say no, then this application is going to be problematic. The trade unions will fight against that and say, at the very least, we require that the contributions to the pension provident fund are up to date before we'll consider any exemption application. So make sure that those contributions are up to date, and then you can simply say yes, and there's the proof of payments, etc. If they aren't up to date, then my strong advice is to contact MIBFA and say, look, we've fallen behind in our contributions. We'd like to catch up, but it's going to be difficult for us to do so because of our financial situation, for example. Can we put an agreement in place that will allow us to catch up over time, etc.? MIBFA won't have any problem with that. That's fairly common. I don't want to say very common, but fairly common. Put some sort of payment plan in place to catch up. And if you then say no, but there's a payment plan in place or C payment plan attached or whatever the case is, then that's fine. Then the unions typically will say, okay, well, this company is at least trying to comply and has got an agreement in place with MIBFA to catch up the contributions or whatever the case is. Then in the case of a financially motivated exemption application, which is the normal or the most common type, you are going to be required to submit your audited financial statements, or latest financial statements, which are probably the 2020 to 2021 ones. If those aren't ready yet, then the year prior, whatever the latest ones that you have, the auditor's report, if you do have an auditor's report, if you do get audited, and the last 3 months management accounts. That's what must be submitted, but please be encouraged or feel free to submit whatever other information you think will be useful. Now, I'll repeat this, I'm sure, in some of the slides to come when we get back to the slides, but the financial information, so the audited statements, the management accounts, any of the financial information that is submitted with this application. Once it's submitted to the bargaining council, what happens is the bargaining council separates the financial information from this questionnaire, okay, and submits the financial information to an independent auditor. The independent auditor then looks only at the financial information, doesn't see the questionnaire or any of the motivation, etc., that we're going to get into now, but just looks at the financial statements of the company and the financial information, and makes a recommendation as to whether the exemption application should be successful or not. And he does this. I'm not an accountant by any stretch of the imagination, but he does solvency and liquidity tests and makes a recommendation. Now, that recommendation is anywhere between half a page and 1 page long. Very, very unusual to have a recommendation that runs into more than 1 page. And although the actual financial information is not shared with anybody other than the independent auditor, the independent auditor does in the recommendation sometimes disclose relevant information, such as losses that might have been incurred or things of that nature. So please be aware of that. I mean, I know that's perhaps not certainly not ideal, and some of these things are very, very sensitive, or some of this information is very, very sensitive. But it is not a case where the trade union, for example, or the trade union officials or employer organization officials, for that matter, like myself, will ever see your financial information unless you send it to me, in which case I'll see it, but nobody else will. Sorry, I've just got a warning note coming up here saying the sound is not great. Can everybody still hear me?
Gordon, I can hear you perfectly.
Oh, okay. All right.
Gordon, if I may just use this opportunity to ask you a question from Bronwyn.
Sure.
She has asked if the company has not in the past 12 months worked short-time or embarked on a layoff process, are you less likely to get an exemption?
No, that's a great question, but no, the answer, no, definitely not. You're not less likely to get the exemption or have the exemption granted. No, I haven't seen that before. I've never heard the argument from the trade union saying with this exemption application they must try something else first. Not at the exemption level. I mean, in your initial consultation with the trade union, they may say, rather than apply for an exemption, why don't we try, something else like short time, etc. But I don't know how that can be much better. I suppose depending on the type of exemption. But no, I wouldn't worry about being less likely to get the exemption if you haven't had to work short time or retrench, etc. I mean, retrenchment is really a last resort. I would certainly advise trying to make use of an exemption process before resorting to retrenchment. Arguably, you'd be legally bound to do that in terms of Section 189. So the independent auditor makes that recommendation. Sometimes the recommendation does quote sort of figures in terms of, like I said, perhaps a loss that has been incurred, or I know there's very often, the recommendation might contain wording to the effect that had the shareholders not loaned the company a certain amount of money, it wouldn't have been, it wouldn't have been sort of a going concern, etc. So there is that sort of information that makes it onto the recommendation, but there's nothing more specific than that. That recommendation is then attached to this questionnaire and sent to the committee. As I said, the recommendation, usually anything from about half a page to a page. However, if, like I said before, I mean, say for example, you've got a situation where you've lost a certain customer, a major customer, very, very recently. So you're going to attach your latest set of audited financial statements, and the audited financial statements don't highlight any problem because the problem has only arisen very, very recently. Okay, please feel free to explain that. It may not even be that apparent in terms of your latest management accounts. If that's the case, bring it to the auditor's attention. If you don't bring it to the auditor's attention, then he's not going to be able to incorporate that into his recommendation. If you do, then he will. Okay. It may make all the difference in the world. It may not, but if you don't bring it to his attention, it certainly won't. So if there is a specific reason why very, very recently something's gone awry, you've lost a customer, whatever the case may be, and that's why you need this exemption, bring that to the auditor's attention and include it as part of the pack that will be given to him to have a look at. Then you've got the motivation and the business plan under 3.13 and 3.14 respectively. The motivation is simply an explanation of what has led to the company needing an exemption. So the way that I assist companies with this is, imagine that you ask me to come and have a meeting with you because you don't know what to do about exemptions. And when I arrive, you say, hi, Gordon, we need an exemption because of the following. That explanation that you then give me is what you need to put in writing and attach to this application. That explanation can be as lengthy as you want it to be, but if it is going to be more than a page or a couple of pages, then it's very useful to provide an executive summary. And I'm sorry to say this, but the harsh reality is the vast majority of people who sit on the exemptions committee don't read the exemption applications themselves before they actually step into the meeting. They have them because they circulated with the agenda, of course, before the meeting starts, but there's only a handful of people, ourselves, Solidarity, most of the employers, Solidarity, but I don't know about any other trade unions, quite frankly, who will actually bother to read any of that stuff. So when we're going through when we get to your particular company on the agenda and your documentation is attached, you'll probably find that some of the trade unions then will skim through the first page of the motivation, and that's about it. So it's very, very useful to provide an executive summary if the motivation is fairly lengthy. Okay. If it is complicated, though, don't oversimplify it. If it's a complicated exemption or a complicated motivation, you're fully entitled to put down all of the reasons, as complicated as they may be, and then that allows us to then motivate on your behalf in that exemptions committee if necessary. If it's very complicated, give me a heads up. You might need to take me through it so I can properly motivate it in the meeting for you. Then the business plan. Now, business plan is not a business plan in the sense that you might present to a board of directors or something like that. A business plan in the context of this application is a demonstration in writing of how the company would catch up to where it would have been had it never been given the exemption. Okay, so say, for example, you are seeking an exemption from wage increases, and you're currently paying the employees at the minimums, and you're not going to pass on a wage increase. Now, our agreement is slightly different, but so this example is not current, if I can put it like that. But historically, what would happen with minimum wages is you'd have a minimum wage, let's say 30 Rand an hour, for example, and then there would be a wage increase, let's assume it's 10%, and then the new minimum wage would become 33 Rand an hour, okay? That doesn't happen with our current agreement, by the way. The standard rates stay the same. They stay the same for the duration of the agreement. So if the standard rate pays 30 Rand an hour and there's a 10% wage increase, then the employees get a 3 Rand an hour increase. But if you were to then employ somebody at that particular grade today, let's say, you'd be able to take them on at 30 Rand an hour. But perhaps let's not confuse the issue. Let's just deal with the principle first. Historically, the new minimum wage rate would move then to 33 Rand an hour. What is then required by the exemptions process is that you would then have to catch up with where you would have been had you never been given the exemption. So then what is expected is, or assumed is, that in the following year, let's assume that the increase in year 2 is also 10%, just to keep the math simple. You would be expected, after having been granted an exemption in year 1, to catch up with the 10% lost in year 1 and the 10% in year 2. So in other words, that employee would be going from 30 Rand an hour to 33 Rand an hour to 36 Rand in some sense, 36 Rand and 30 cents, let's say. And you would be expected to catch up to that minimum, okay? And the business plan would be how you catch up. It doesn't have to be all in 1 year. So you might say, for example, if you've applied for a to pass on a 0% exemption in a year where the increase is 10%, you might say, well, I'm going to add an extra 2% every year for the next 5 years or something like that. That's your business plan, okay? As you can see through my explanation of what a business plan is, it's not always applicable depending on what the exemption is that is being sought. An exemption from leave enhancement pay, a business plan isn't applicable because there's nothing to catch up with. You're asking for an exemption not to pay leave enhancement pay. You don't pay leave enhancement pay, and you're not expected to then pay it at some later stage, unless that's what you're applying for specifically. because you can, of course, apply to for an exemption not to pay leave enhancement pay now in December, but perhaps at some point next year. That's fine. But if it's unless it's something like that, business plan would be not applicable in that case. All right. Again, here, guys, business plan. And I say this reservedly, but quite possibly the simpler the better. Okay, because very complex business plans might well go over the head of some of the exemption committee participants, myself included, and best just keep it as simple as possible. All that is necessary really from an exemption committee point of view is a demonstration that you understand that you're going to now need to catch up with where you would have been had you not been granted the exemption in specific circumstances as I've demonstrated. Okay. Just as a note, in the application form itself, it says if anything is missing, it's going to be problematic. You'll either have the council itself administratively send it back and say there's something missing, you need to attach this, and then there'll be a delay, obviously, or it'll get to the exemptions committee, and in the exemptions committee meeting, somebody will say there's something not right here, we've got to send this thing back, and there'll obviously be a delay there as well. Right, it's then signed off, and then there's the various forms that I'll whip through. There's, this is a very bureaucratic document, and there is some repetition here, but it is what it is. So the first form is the application for exemption from the MEIBC. It talks about the representatives of the employee representatives, that is confirming that they've been consulted with by management. And in this case, the form actually says that the employees unanimously accept and agree to the reasons that have been given by management for the exemption being sought, etc. Very, very often your employees, after having been consulted, will look at this and say, but we don't agree. The various options available to you. The most common is to simply cross out unanimously accept and say don't agree or don't accept or whatever the case is. Like I said before, the obligation is to consult. The obligation is not to reach an agreement, okay? So it really doesn't make much difference. Try and reach an agreement, because an agreement is incredibly useful. If an agreement is reached between a company and the staff, it's very, very unlikely that the bargaining council will interfere with that agreement. So in other words, if you do reach an agreement with your staff, then the bargaining council will say, the exemptions committee will say, guys, there's a company that has reached an agreement with the staff for whatever it may be that you're seeking in terms of the exemption. We simply grant it. We've done that very often, even where the auditor says the financial information that's been provided doesn't support an application for exemption here. But if there's an agreement, the committee will say, guys, if an employer reaches an agreement with his or her staff, why do we interfere with that? Grant the exemption. So do try. I mean, it's very useful if you can get an agreement, but if you can't, don't feel all is lost. It's certainly not. Just simply say that agreement hasn't been reached, or change the wording or whatever the case is, and note it on the form. Very, very often, the employees will refuse to sign this document altogether. Note it on the form, refuse to sign. Okay, if you've got your minutes and if you've got your attendance register, that's proof of consultation, and it says refuse to sign. It all makes sense. It shows that the employees are unhappy, didn't support the exemption application, but have been consulted with. That's the requirement and the legal obligation met, and the exemption can be processed. Okay. Similarly, here's the employer trade union acknowledgement of the application. Okay. Sort of similar wording, and again, it's basically just repetition. Here you might encounter the same thing. You might get union organizers, shop stewards, employees refusing to sign this. If they sign it, great. If they don't, simply note refuse to sign. And similarly on this page, the third page as well. Okay. So don't feel that you have to use these forms. All right. If you have attendance registers from the meeting, if you have minutes of the meeting, those can all be attached, and simply note on these forms, see attached register, see attached minutes, see attached whatever supporting documentation, whatever it may be. Okay, but don't leave them blank. The minute they get left blank, the trade union representatives on the committee start to say, oh, this thing hasn't been filled in completely correctly, or whatever the case is, and they're rejected. Okay, that's the application form itself. I just want to then stop sharing that document. We'll go back to the slides, but maybe we can pause here if there are any questions on the actual application form itself. Okay. Silence is acquiescence, which is fine. We'll then move back to the slides, and I hope they are showing. Just to reiterate a lot of what we've said, of course, but also to make further points. So we said before we moved our attention over to the actual application form itself that the exemptions policy, the exemptions process itself is fairly effective. It's not ideal. It is cumbersome. It is lengthy. It is problematic, and we are looking to address that, but that's going to take some time. Hopefully by the middle of next year, it'll be done. So let's have a look at the composition of the committee. As I said, or as I alluded to earlier, any structure of the bargaining council for that matter, and these regional committees are no different, consists employer organization officials, employers or employer organization officials, and trade union representatives in the form of shop stewards or trade union officials. We are, as SAIFA, the only employers organization that sends actual employers to these sorts of meetings. We have employers, executive committee members specifically, that sit on these structures. I do as well as an official. None of the other employer organizations do. They just send officials. The trade unions sometimes send shop stewards, but for the most part will send full-time officials to these meetings as well. So the bargaining council themselves, they don't play any role other than facilitating the meetings. It's the actual parties that get involved and compose the committee itself. There's obviously an equal number of employer organization officials and trade unions on any committee. Okay. The exemption applications are decided on a regional basis. So there's the exemption applications that are submitted by Gauteng-based companies will be dealt with at the Gauteng regional office. Those in KZN will be dealt with in KZN region, Cape, etc., etc. That in itself is somewhat problematic for companies that have branches in different areas, because we have encountered a situation often where a company will need an exemption, will submit exemption applications per the regions where the different branches are, and some regions will grant the application and some regions won't. So there's a lack of consistency in that arrangement, in that setup, which we are looking to resolve through our discussions with Solidarity as well. Solidarity are well aware, they acknowledge that there is that problem. How can you have a company that applies for an exemption, the company is facing the problems that it's facing, not necessarily a regional problem, yet in Gauteng they get the exemption, in KZN they don't, for example. That's obviously incorrect and problematic, and we are seeking to address that. The committee representatives are expected to wear their MEIBC hats, and by that I mean they're not supposed to represent the organizations that have sent them to the meeting. So I'm not supposed to be sitting there representing SAIFA. I'm supposed to be there representing the MEIBC, putting my SAIFA hats aside and putting my MEIBC hats on, and doing what is in the best interests of the industry, even when sometimes it might not be in the best interests of my particular organization. For the most part, in my experience, most of the committee members do behave in that fashion or in that manner. Sometimes, unfortunately, some committee members don't. We have encountered situations where a particular trade union official has taken an exception with something that a company has done. It might even be a personal issue that the guy has with somebody at the company, or whatever the case may be, and then simply, argues to reject the application. Usually those are not too problematic, because the consensus will still be reached within the meeting itself that, well, that's not a relevant issue. It's quite clearly something that you've, be in your bonnet with a particular person or whatever the case is. And there'll, let's say, be a vote sometimes, and the vote will carry carry favor with the application or whatever the case is. So it's not too much of a problem. We haven't really encountered difficulties, particularly in the Gauteng regional office. I know that in KZN there was a particular trade union official who was quite problematic, that he actually became known as Mr. Reject, because he would simply reject any application, irrespective of the facts, etc. But there is a lot of pressure then placed on guys like that to give motivation and reasoning why they're rejecting the application. And even if it does lead to an unsuccessful application at an exemption committee level, that reason is then passed on to the Independent Exemptions Appeal Board. And you'll see the composition of that board just now. And when they see that this particular person, this particular trade union official, for example, didn't actually have a proper reason to reject the application, it'll be overturned on appeal. But for the most part, I think there is a mature approach taken by the committee members in terms of dealing with these applications. The independent auditor, I have mentioned the role of the independent auditor. So just to reiterate that financial information which we spoke about and is required in terms of the application is examined by the independent auditor. And as I said, he performs liquidity and solvency calculations. Don't ask me what they are. I'm not an auditor, but they seem to be fairly simple, high-level liquidity and solvency calculations on the figures presented. And makes a recommendation either supporting the application or not. That recommendation, like I said, is a page and a half, or half a page to a page, not usually more than a page, that is then attached to the application, and the recommendation is then seen by the exemptions committee itself. But the committee isn't bound by that recommendation. I think I made that clear earlier on. Even where the auditor might say that the financial information doesn't support the application, we have nevertheless granted exemptions in the past for specific reasons, chief amongst which, as I mentioned, is where there's an agreement between an employer and the employees. So we're not bound by that auditor's recommendation, but it does serve as a guide. It's one of the factors that is considered in either granting or rejecting an application, as the case may be. It does hold quite a lot of weight, particularly where there isn't an agreement with staff. So that's why I say, if there is additional information that you want the auditor to consider, please put it in. Okay, put it in, because if he doesn't have it at his disposal, then it's not going to come into his thinking. Might make it less likely that he makes the recommendation that you want. All right, so then I think really sort of recap the exemption process itself. Where there's a decision taken by management to apply for an exemption, or certainly contemplate exemption, then the sort of steps that we would recommend is try and get all the necessary documentation up front. You've now got that. It was sent out as part of the meeting invitation, the actual application form itself. Then make the preparations for the exemptions process, identify the interested parties being your employees and any trade union that they may be a member of. Okay, get the application forms, you've got them. You then call consultation meetings with your employees and their trade union if applicable. I was asked the other day whether the consultation has to be in person. It doesn't. There's no requirement that in-person consultations can take place. It's very, very common, obviously, given the circumstances these days, to have web-based meetings and consultations. So Teams meetings may be the order of the day, depending on your circumstances. There's nothing even stopping you from conducting that consultation via electronic means like email, etc. It's just more difficult, and the trade unions prefer to have a face-to-face, even if it's via online, but a meeting where they can ask questions, where they can caucus with their members, where they can bounce ideas off one another and that type of thing. So get stuck in. It's not necessarily the easiest consultation to go through, but it is required, and putting it off isn't going to help. Just make the arrangements and have the meetings. Okay, like we said, consultation is required, not an agreement. So even where the employees or the trade union really do argue back and don't want to support the application itself, don't worry too much about that. Try and get their agreements, as I indicated, but if you don't, it is what it is. Note that they wouldn't agree for whatever reason, and note that on the forms and submit them. Proof of that consultation, however, is absolutely essential. If you don't show that you've consulted, the application is just going to get kicked back. It's going to get kicked back, and the bargaining council is going to say there was no consultation. It has to take place. Either do the consultation and resubmit, or start all over again. Okay, and if you have to start all over again, certain deadlines might be missed. There are certain deadlines in certain circumstances that need to be adhered to and that type of thing. Okay, so complete the application form. So once you've consulted and you've got the proof of consultation, you've got your attendance registers, you've got your minutes, you've got your a documentation that shows that you've consulted, complete the rest of the application form. Like I said, don't skip any of the sections. If you're not sure of what a particular question is asking, rather, ask. Certainly you can ask me. I've dealt with these applications for years. Phone through and say, or send an email, however you prefer, and say, listen, what does this particular question mean? Or this is what happened when I was consulting. The guys refused. What must I do? How do I complete this particular document, etc.? And I'll guide you as best I can. Then you attach your supporting documentation, so the financial information that we spoke about, latest set of financial, your latest set of financials, your management reports for the last 3 months, etc. That motivation, which is your explanation of what the difficulties are being faced by the firm, and the business plan, if applicable. Depending on the circumstances, like I explained, if you are applying for an exemption not to pay wage increases, there might be a need for a business plan. If it's for leave enhancement pay, then a business plan isn't really applicable. Okay. However, let me just say that at this stage, even though it's not applicable, I don't want to encounter a situation where perhaps an inexperienced trade union official who sits on the exemptions committee says there's no business plan, we've got to reject this thing. Perhaps have a sentence or two under business plan saying that the exemption sought is leave enhancement pay, therefore no business plan is applicable, or something to that effect. Okay. The committee, as I explained towards the start of the presentation, will deal with that application hopefully within 30 days of the receipt by the bargaining council. If the bargaining council receives an application and something's missing, they'll send it. They might send it back. If it's a fairly simple issue, they'll send it back and they'll say, such and such is missing. Please attach it and resubmit, etc. Once you attach it and you resubmit, and the bargaining council receives a so-called complete application, then it's got 30 days to grant or reject the application itself. And as I said, most of the meetings are happening now every 2 weeks, fortnightly, to be able to meet that requirement, which is part of the Act. Right. Now, very, very importantly, the rule when it comes to exemptions that has been observed by the bargaining council for decades is, as long as an exemption application has been submitted, you may proceed as if you've been granted the exemption. Now, that's very, very important, particularly now. The negotiations took so long to conclude this year and were concluded so late that it is very, very likely that companies will apply for leave enhancement pay or exemption from leave enhancement pay and not have an answer back from the council by the last working day of this year. It's very, very likely. Okay. If that is the case, guys, then the rule is that you proceed as if you've been granted an exemption. So in other words, then you don't pay out leave enhancement pay. Okay. Presumably you won't be able to, otherwise you wouldn't be seeking the exemption in the first place. But don't go and borrow money from somewhere to pay leave enhancement pay in the hope that you're going to get a positive answer later. Okay, that's going to be problematic, because if the answer comes back, yes, you have the exemption, to try and recover that leave enhancement pay from your employees is going to be impossible. Okay, so proceed as if you've been given a positive answer. Proceed as if your application has been granted, unless you hear otherwise. Okay. In which case you can appeal, and we're going to go into that now. All right. So if you have submitted your application and you haven't received an answer by, let's assume you're closing on the 15th, for example, of December, then you don't pay out leave enhancement pay on the 15th. Please, guys, tell your employees this. They may not want to hear it, obviously, but rather they are aware of what's going to happen up front and are not unpleasantly surprised. We have had a situation in the past, probably more than once, where employees have ended off. They've had the last day, or whatever the case is. They've gone off on leave. Company's closed. They've gone to the ATMs, their banks, etc., to withdraw money. They've seen that they haven't been paid leave enhancement pay. And upon their return to work in January, they've immediately proceeded on strike action, protected or otherwise. Okay. Wouldn't be protected if they don't follow procedure, but very, very problematic then start to the new year that the company then has to deal with. So rather say to them up front, guys, we've submitted the application. You know this. We consulted with you and your trade union if applicable. We've submitted the application. We haven't heard from them. If we haven't heard from them by the time we have to close, we are not going to be paying leave enhancement pay out. If the bargaining council then rejects our application, we may or may not appeal, but if we do and the appeal is unsuccessful, then we'll pay out leave enhancement pay, but it'll only be next year. Rather manage the expectations so that you don't have employees acting out of emotion and you have unprotected strike action and go slows and overtime bans and things like that when you come back to work, or even before, depending on what's said. Then, if the exemption application itself is not successful, if it's rejected, then you do have the right to appeal within 14 days to the Independent Exemptions Appeal Board. The functioning of this board is quite problematic because what they really do is they wait until there's sufficient appeals and then they process them, and that can be quite a long period. The Independent Exemptions Appeal Board is an independent body, as the name suggests. It's necessary in a legal requirements in terms of the Labour Relations Act, as we described earlier, or we said earlier. But it's a body that comprises independent auditors, lawyers. It's got a secretary, etc. And they charge the bargaining council, which is neither here nor there. But they don't operate like the bargaining council's exemption committee itself does. Like I said, we have meetings every 2 weeks so that we can get through all the applications that may come in. The Independent Exemptions Appeal Board will wait until there's enough work to actually warrant them getting together and having a meeting and coming in from wherever they're coming in and processing the applications. It's not ideal. It's something that urgently needs to be addressed. But for the most part, when the Independent Exemptions Appeal Board does apply their collective mind to applications, they are fairly reasonable and good, and the appeal process is also very, very successful for employers, particularly because so many exemption applications, and I say so many, but put that in context. I've already said that 80% of exemption applications usually are successful in the first instance, but of those that aren't, quite a lot of them can be because of a particular trade union organizer being unhappy or saying no, we don't support it because of some arbitrary reason or something like that. The Independent Exemptions Appeal Board will more than likely overturn that and grant the exemption. So well worth appealing to the Independent Exemptions Appeal Board. The other issue is that if the application itself has been rejected at exemptions committee level, all right, and you put in an appeal in time, then you don't have to then meet the requirements. So say, for example, you're applying for an exemption from paying leave enhancement pay, the committee rejects it, okay, but you appeal, you don't have to then pay leave enhancement pay until you hear from the Exemptions Appeal Board. That underlying principle of you wait until the final step and the final no before you have to comply still applies in this regard. So you can make use of that, and that's very important when it comes to issues that are concern cash flow and that type of thing for any business. The Independent Exemptions Appeal Board does process probably 95% at least of their applications on papers. So there's no appearances by companies. Just by the way, I'm sure it's fairly self-evident, but at the exemptions committee level, there's no need for the company to come and present any evidence or anything like that. It's just the application which is dealt with on the papers. Same thing in the Independent Exemptions Appeal Board level. The appeal is done on the papers, and there's no appearances, no oral arguments, etc. There is capacity for it. The rules and regulations do make provision for oral arguments, to happen. If there's a need for it, it's very, very rare, and it's usually reserved for the presentation of new evidence. If you feel like it's going to help your exemption application, if you introduce this new evidence and you are there to motivate it, then put that in, and the necessary arrangements will be made for that to happen. On appeal, the Exemptions Appeal Board must consider the criteria in clause 54 of the agreement. You've got that. That was the excerpt from the exemptions policy, which I sent through to you. Any other criteria established or approved by the MEIBC Management Committee, what we call the MANCO, the financial hardship on the applicant company, the potential impact. So I say the applicant company, but of course exemptions could be appealed by the trade unions as well, or the employees. Quite rare for that to happen, but it is possible. Okay, usually a company is the one who appeals, because it's the company who will apply in the first instance, of course. The potential impact on the collective bargaining process. It'll be interesting to see how the Independent Exemptions Board deals with that particular aspect, because the collective bargaining process is in such a state of upheaval at the moment within the MEIBC, as you all know, that that might be quite interesting to watch, but we'll see what they do there. What other alternatives were considered to an exemption itself? And the need to avoid retrenchments is quite an important one, and any other relevant factor. And the decision must be given within 2 weeks of the meeting. So once the meeting happens, it doesn't take long for the results or the final answer to be disclosed. But it can take, depending on the circumstances, some time for the actual meeting to be convened itself. Having said that, as one might expect, towards the end of the year, when in the run-up to shutdown, with the payment of leave enhancement pay, etc., there's a flood of exemption applications that'll come in. So you'll probably see a number of Independent Exemptions Appeal Board meetings happening in the start of the new year, because there will be, depending on the success rate of those applications, a number of appeals that will be lodged. So at this point in time, I wouldn't foresee any problems in terms of any exemptions and the convening of that board meeting. All right. So that concludes the slides for this morning. I know that I've been going through them fairly quickly, and I haven't really been stopping at all for questions and answers. So perhaps let's deal with that now. Are there any questions or anything that somebody wants to go back and revisit? Any points that anybody wants to make? Please do so. Do so now. And now I'm back on the chat, so if you would like to raise your hand, or otherwise just untoggle your microphone and ask the question, we'll deal with it. Okay, so I see there's a question being asked in the chat. How in advance should one apply for an exemption? So there's guidance in terms of the actual exemptions policy itself, and ordinarily, it depends on what exemption is being sought, of course. So let's say, for example, you're applying for an exemption from a wage increase. In any year where there aren't wage negotiations happening, the wage increase becomes due. In our case, with our agreement in the plastics agreement and in the CIFSA agreement, wage increases are effective from the 1st of July of any given year. If you're applying for an exemption on wage increases, then you've got 30 days from the date on which that wage increase becomes due. Okay, so in other words, you've got until the end of July to apply for an exemption on wage increases. With leave enhancement pay exemptions, the deadline, I think, is the end of October in any ordinary year. Obviously, that's not that deadline isn't going to be applicable this year, because the wage negotiations continued beyond that, and that wouldn't be a practical deadline. But those are the deadlines for those two exemptions. Any other exemption, there isn't going to be a deadline, obviously, because those exemptions could be sought at any point in time. For example, overtime. You might need an overtime exemption, when you need it, and so there won't be any deadline on that. Only deadlines will be the wage increase exemption, end of July, and LEP exemptions, end of October, ordinarily. At the moment, there's still time for exemptions applications to be submitted on both, because agreements have only just been concluded. Okay, is there any further questions? So I'll just try to go to the chat. Okay, I see someone's typing a question, but in the meantime, anybody want to raise any issues, you're very welcome to just untoggle your microphone. I hope that the functionality is working. I can never tell if there's silence, whether it's a good or a bad thing. Hopefully it's a good thing. Okay, I just want to see if there's any other questions being asked via chat. Okay, all right, folks. Then, in that case, then, in the absence of any further questions, I would just like to thank you for coming. I hope you found it interesting. I know that you did go through it fairly quickly. And if you do have any questions, obviously I do understand that the subject material itself can be somewhat sensitive. So you might be a little bit reluctant to ask questions on this forum in front of everybody else, which is completely understandable. If that's the case, please feel free to contact us, directly, telephonically, or by email, or however you prefer. If you want us to come out and assist with an exemption application, we can certainly do that, and we can certainly guide you in terms of putting the application together itself. I think just for everybody to note, for those of you who do have trade unions on the shop floor, there are, because of the circumstances facing our industry, a lot of companies that have, let me say this differently, a lot of companies whose employees are members of a trade union that is not party to our bargaining council. That is happening more and more. So there's trade unions now getting involved at companies who don't know about our agreements, who aren't familiar with the structures of the bargaining council, or aren't familiar with the exemptions processes. On the whole, we don't necessarily have any difficulty with trade unions like that. It's simply a case of bringing them up to speed with what the requirements are, what it is that is necessary to do, etc. And we're very happy to assist in that regard. Companies that have NUMSA on their shop floors, I shared with you a little bit of the experience. I'm singling out NUMSA in particular because they tend to be the most argumentative and problematic with regards to exemption applications at the moment. It just depends on the union official that you are dealing with, but certainly we're more than happy to get involved and assist if you are having difficulty even in just reaching them or consulting with them or whatever the case is. Just let us know and we'll get involved and try and assist as best we can. All right, folks, then in the absence of any further questions, I'm not going to keep you unnecessarily. I think there is just one more question about to pop up on the chat. Yep, seems to have disappeared. Okay, all right, folks. Then I think then we'll leave it there. Thanks very much for your attention. And as I said, any further questions, please reach out to us, and we'll be more than happy to assist. All right. Then, with nothing further, once again, thanks everybody. Please do have an enjoyable weekend and a good few weeks until the end of the year. Any questions, come back to us. Thanks very much.